to ensure the fitness of nominees for a lifetime appointment to the federal bench or to any of the other positions for any of the committees on which they appear. I ask each nominee these two questions, and I will ask them of you. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator Hirono.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
Judge Barrett, do you think it is appropriate for justices to consider real-world impacts in their decision-making, as Justice Ginsburg noted in a number of her dissents?
Well, Senator, the doctrine of stare decisis is a good example of that because the factor reliance interests takes into account the real-world impact, the way that people have ordered their affairs and relied on decisions. So there are contexts, yes, in which considering the impact is expressly part of the doctrine.
So you would say then that you've been listening to all of us here yesterday as well as today talk about the real-world impact of the striking down of the Affordable Care Act, and would all of those impacts be factors that would be important for you to consider should you be a justice?
Senator, to be clear, I have the utmost empathy. The stories, that you have told, including the story of Veronica's family, are very moving. If I were a justice, the commitment that I would make to you and all people affected by the laws is that I would follow the law as you enacted it, and I have no agenda. I would not be coming in with any agenda. I would do equal justice under the law for all and not try to thwart or disrupt in any way the policy choices that you and your colleagues have adopted.
So are you saying that the impact of the Affordable Care Act on the millions of people who rely upon it, that those who you would deem to be policy considerations that we should address?
Senator, I think that you choose the law and you've structured the Affordable Care Act. It's a complex, long statute. I think you set the policy, and then I think when a court has to interpret the statute or decide how it applies in a certain circumstance, the court looks to traditional legal materials, looks to the briefs. It listens to the real-world impact on the litigants who are before the court arguing the case, because every case affects real litigants. Mm-hmm. Every case affects real people. I said in my opening statement yesterday that, when you pass statutes, they're often named for the co-sponsors of the bill. But cases decided by all courts are typically named after the parties. They affect real people.
Judge Barrett, so are you saying that all of the stories that we brought forth yesterday and the millions of people who are relying on the Affordable Care Act can rely upon you, that those impacts would be considered by you, that you would consider those to be legal arguments that you would consider? Because when you say that you're going to make a decision based on the law, the real-life stories that we've been talking about, you would consider those to be part of the law?
Senator Hirono, every case that comes before a court, because as I was saying earlier, no case comes before a court unless it involves real live people who've had a real live dispute. And it is the job of a judge deciding every case to take into account the real world consequences of the parties before it.
So does that mean that you would agree with Justice Ginsburg that the court should be taking into consideration the real-life effect of the decisions that they make? Because she wrote a number of dissents saying that the majority did not consider the real-world impacts of their decisions. So are you aligning yourself with Justice Ginsburg in terms of what you would consider real-life impacts and the effect it would have on your decision regarding the law?
Well, Senator, I don't know what context, the particular context in which Justice Ginsburg was describing that. I think what I'm trying to align myself with is the law. and that I will take into account all factors, including real-world impacts, when the law makes them relevant, as it clearly does, for example, in the doctrine of stare decisis.
I'll get to your views of precedent in a moment. I'll give you a real-life example of Justice Ginsburg. In Ledbetter v. Goodyear Tire and Rubber Company, Lily Ledbetter worked at a Goodyear plant for 19 years. As an area manager, a position held mostly by men, Lily was paid less than all of her male counterparts. When she eventually realized this stark inequality, she sued for pay discrimination, and a jury agreed. But the Supreme Court kicked Lily's claim out of the court for being too late. The conservative majority, including your mentor, Justice Scalia, interpreted Title VII's 180-day time limit to mean that Lily had to have filed her claim within 180 days of when her salary was decided, instead of accepting the common sense approach of viewing her paychecks as an ongoing part of pay discrimination. Justice Ginsburg strongly disagreed with her conservative colleagues' approach to the case. In her dissent, she pointed out the many challenges women face in discovering pay disparities, including how many companies keep salaries confidential. In a stinging rebuke, she said, quote, "The court does not comprehend or is indifferent to the insidious way in which women can be victims of pay discrimination," end quote. In another case, in 2018, in Epic Systems Corp v. Lewis, employees who had been illegally underpaid joined together to seek back pay in court. To block this effort, their employers forced them to sign an arbitration agreement prohibiting collective actions. They actually had to sign these arbitration agreements in order to even have a job or keep their job. So the Supreme Court's conservative majority, including Justice Scalia, sided with the company. They interpreted a general federal arbitration law to override two worker protections laws instead of recognizing that the worker protection laws fall sensibly within the exceptions in the arbitration law, meaning that the worker protections laws should prevail. Again, Justice Ginsburg strongly disagreed with the majority's approach to the case. In her dissent, she pointed out that blocking joint lawsuits would deter most workers from seeking individual unpaid wage claims because of the cost of lawsuits and fear of retaliation. She warned the majority's decision would result in hurting vulnerable, low-wage workers.